if I still have it, 3 minutes to my colleague, Mr. Beltzer.
Lordship, I will be brief. I want to respond to the following points of law raised by the other side. From the other side, a lot of hue and cry has been made about Article 145, Article 7, and the word shall. Lordship, the Black's-Law Dictionary, Brian Garner, 10th or 9th edition, confers 6 different meanings to the word shall. So for the plain text meaning of the word shall, the dictionary in law gives it 6 meanings. So shall cannot only mean mandatory, it can mean any other thing. Black's-Law Dictionary. In terms of the reading of the Constitution, the Constitution can be read multiple times. It's not only the textual reading of the Constitution that counts. If I had time to share with my friends that we drink uji once in a while on the other side, there's a book by Professor Philip Chase Bobbitt that canvasses 6 methods of reading the Constitution. Textual reading, moral reading, structural reading, primal reading, purposive reading. Purposive reading has been read in our Constitution, Article 259(1). It has about 4 elements. If we go to 259(3), living through reading, first articulated by the case of Edward versus Sankey, 1930 Canada. What does that mean to this honorable court? There's more coming. So while they were telling us that we are running away from the case, they're telling them, we are ready and we're going to explore the full depths of this Constitution on the merits. Please consult this abstract. We are ready to go. The question, another point was raised here, that the President is protected by the Constitution in his role in appointing a prophylactic Deputy President in a nominative capacity. The Constitution in that manner is deemed as a constitutive charter. It creates institutions. The Constitution, going by the violations that have been raised on this side, touching on constitutional rights, plays a protective capacity. So this court will, on the merits, be asked to balance those 2 shades of the Constitution. The Constitution as a constitutive charter, the Constitution as a protective charter. We will discuss that on the merit. My good friend, Senator Professor Tom Ojenga, expected orders need to be lifted for the reasons he raised. They have not answered to you, to your satisfaction, and we attached a case in our submissions, the decision of the Ghanaian Supreme Court, Barclays Bank, in our submissions, the test for overturning a decision made ex parte. They have not satisfied you as to why the decisions of Justice Mongo should be overturned. The issue here is broader than mere compensation by way of sums of money from an individual. The broader question here is the Constitution and how offices of the Constitution are occupied. Article 1, Article 2, Article 3 of the Constitution. My good friend and teacher, Bubomithian Kwolo, that there is an absence of a specific textual authorization for judicial involvement in the court. Again, we refer to the various methods of reading the Constitution, so that if we go by their own arguments, and I had my good friend Mr. Somane talk of reading in, as a remedy available to this court in Article 23. Reading in can't be read. We need to start it for any other constitutional methods here. We can use that as a remedy. So the absence of express textual bar in the Constitution does not preclude this court from reading the Constitution in any other way. Several documents are cited here, the Bomas draft, the Kilifi draft. What was missing from all that discussion is the commentary from individual delegates. Because if we had to look at the travel, the preparatory documents, where are the comments from the delegates? Where is the report of for the Committee of Experts? And in any case, the Constitution 2010 enjoys its imprimatur, its force in law, by the seal of approval it was given by the citizens through a referendum in August 2010. And any law interpreted and read into the Constitution post the promulgation, that becomes law. These courts have been laboring to do that for some time. Finally, Mr. Minimum, the Senate sits in a quasi-judicial capacity. Yes, the Senate sits in a quasi-judicial capacity. Article 47 kicks in. This court has to exercise judicial review. Madison versus Marbury, 1803. It is inherently the province of the judicial branch to say what the law is. I submit.
My Lord, for purposes of the second application, Mr. Ndegwa will, in about 5 minutes, will